Every case has vulnerabilities from a defense perspective. So as a defense attorney, I would expect Kohberger's lawyer to really go after some of that cell phone data. It's a map of forensic evidence and placing Brian Walsh in the locations where that forensic evidence was found. So the jurors are going to be thinking, how should somebody be reacting in this circumstance when their beloved wife and son have been brutally murdered? When both of these witnesses are longtime family friends. One of them said he's basically another Murdaugh family member. Sophie's filing uses the word abduction, but the word abduction is used in the context of a legal statute. It's not truly an alleged kidnapping. That would be a different sort of application. Now we have Alex Murdaugh presenting this alternative theory of what could have happened on that night right away, immediately. One of the first things he says to the responding officers.
Prosecutors have made a big deal out of there being no defensive wounds. The defense at the beginning of the case foreshadowed that Paul was turned. His hands might have been like, maybe weren't like this.
The prosecutor here is showing the jury that these financial crimes impacted individuals and that Murdaugh was able to sit across from them and tell them how their cases were going, how much money they were getting, and lie directly to their faces.
Oftentimes, if the state thinks that it could potentially taint the investigation, taint the jury pool, they'll say, hey, we need to keep this out of the public eye, especially when you have a case like this, where the interest, the media, it's so involved in the case. The DA has been under scrutiny in San Francisco specifically, but I do think it's such a complicated issue. It's hard to say what the answer is. In this particular case, we don't really know anything about this particular individual to make an assumption.
He will likely plead not guilty, and he will be released on his own recognizance.
But that's just the beginning. There's other cases that are working their way up. And to the extent that different federal courts come out on the issue in different ways, well, that's a circuit split.
How is this going to be linked back to Lori? We know that's what the defense raised in their opening argument. We know that's where they're going.
If this representation issue is not resolved, Keefe D will have a court-appointed attorney. The infraction itself is only $300, okay? So a drop in the bucket in comparison to the damages that we could see play out. This does not require intent to kill. It's what's called a recklessness standard. It means that Penny saw there was a risk, there was a known risk of death, but he ignored it.
We know that there's going to be a focus on the mitochondrial DNA evidence, so defense attorneys are going to be looking at that and thinking that that's going to be a major component of this case.
It's very difficult to ascertain whether or not this is violative of the law, the Privacy Protection Act, or whether the circumstances fall into one of the very, very limited exceptions. So from a defense perspective, you say, okay, the pizza crust matches your saliva. Well, fine, now we know it's your pizza crust, but that's all that means. His credibility is shot. That's likely why, as part of this plea deal, he had to take a polygraph test. He had to put his statement on the record, take the polygraph test to give the family some semblance of maybe this is the truth.
We know what the facts are going to be. We know what a lot of the evidence is going to be. As far as this death penalty argument, this filing was a real bombshell. This filing says that Lori Vallow was the master manipulator.
The judge right now, his job is to weigh what's called aggravating and mitigating factors. Of course, aggravating factors are going to come from the prosecution. Mitigating factors, that will come from the defense. The victim